To understand special education in our schools currently, it's important to examine the history of special education, how it developed and came to be in its current form to serve children and students with special needs. Our learning target over the next few minutes is to develop a broad understanding of the history of special education. You'll be asked to complete a short formative assessment at the completion of this unit, so feel free to pause, go back, or even to print specific information as you proceed. Special education in its current form has been influenced by a number of legislative acts, provisions, amendments, reauthorizations, and public policy, all designed to meet the needs of students with disabilities. In 1965, for the first time in the United States, there was a federal commitment to provide education for students with special learning needs. This law, referred to as the Elementary and Secondary Act of 1965, was designed to provide a commitment to the educationally disadvantaged and provide something for everyone in our public schools. By 1974, the federal government directed states to develop state plans with timetables to provide full opportunities to children with disabilities. A key component of this law was a mandate for the student to be placed in general education wherever possible. For parents, this law also provided procedural safeguards for identification, assessment, and placement. In 1975, the Education for All Handicapped Children Act was put into law. From the initial legislation in 1965, 10 years later, Congress noted that there remained an excessive number of children who were being excluded from public education, and too many students were receiving inappropriate educational services or being placed inappropriately in segregated settings due to misclassification. Public Law 94-142 increased funding significantly by placing the responsibility on the states to fully educate students with disabilities. However, in order to receive the money, there was a mandatory requirement that any state electing to receive federal funding was to follow federal requirements. A main component of the law was to ensure that the rights of the parents and children were protected. There were 6 basic principles included in Public Law 94-142. First, zero reject was put into place. This entitled all students to a free and appropriate public education, also known as the acronym FAPE. This means that students receive their education and services free of charge. Secondly, the law required that a non-discriminatory assessment process for placement into special education be in place. Third, procedural due process was included. The fourth concept in the law was the least restrictive environment for the student. This concept tied back to the law in 1974, where children were placed into general education whenever possible. A fifth principle of parent participation was included in this law. Finally, the sixth principle introduced the Individualized Education Plan, or what we now refer to as the IEP. In 1986, there was an amendment to the 1975 Education for All Handicapped Children Act. This act added Part H, which provided services to children 3 to 5 years old. In 1990, IDEA, or Individuals with Disabilities Act of 1990, Public Law 101-476 was passed. During reauthorization in 1990, the title of the law changed from Education for All Handicapped Children Act to IDEA. In this legislation, Part B services were expanded to students 18 to 21 years old. This legislation also included services for assistive technology and social work. Services under the law were expanded to include children with autism and traumatic brain injury. The next piece of key legislation was introduced 25 years after the initial federal commitment to students with disabilities. In 1991, early intervention for children birth to 3 years old, along with transitioning to preschool, was added. The IFSP, or Individual Family Service Plan, was introduced as a plan for early intervention. The IFSP included the family and gave the same safeguards and specialized services as an IEP. By 1997, there was another reauthorization of IDEA. This reauthorization also included protection of students who are dangerous. This outlined that students who are dangerous can be removed from the school setting, but the district is responsible for FAPE, or free and appropriate public education. This legislation also required that students with IEPs need to have district-wide assessments. The mediation process was also introduced at this time, and parents could choose to go straight to litigation. The law also required states to provide mediation and for schools to resolve differences about placement. In 2004, IDEA was again reauthorized. In this legislation, assessment procedures for state evaluations were updated with clear expectations. These included, first, using a variety of assessment tools and strategies. Secondly, not to use a single measure or assessment as a sole criterion for evaluation. 3. Using technically sound instruments that are not racially or culturally discriminatory and are valid and reliable for their purposes. 4. Using instruments in native languages and form to provide accurate knowledge of what the child knows. And 5. Administering assessments through trained and knowledgeable personnel. IDEA 2004 also included a definition that special education teachers be highly qualified. With our changing student population, there were provisions to ensure that children who are homeless or mobile receive appropriate education. From a parent perspective, the law provided changes and procedural safeguards to require a resolution session prior to a due process hearing. If the parent makes a complaint, the AEA has 15 days to act on it, which must occur prior to a due process hearing. If not resolved within 30 days, the case automatically goes to due process. For teachers, a significant component of the law included compliance monitoring to focus on student performance. This would be why many teachers and AEA staff now use the term progress monitoring. In 2001, No Child Left Behind Act, or Public Law 107-110, was put into law. The purpose of this legislation was for all children to have a fair, equal, and significant opportunity to obtain a high-quality education and reach, at minimum, proficiency on challenging state academic achievement standards and state academic assessments. NCLB contained 10 sections called titles. These titles focused on academics and reading, training high-quality teachers, and focusing on language instruction for ESL students. While NCLB was not specific to special education, it did impact the educational system significantly. NCLB and other provisions, such as the Iowa Core Curriculum, are ensuring that students have access to high-quality, rigorous, and relevant curriculum driven by data-informative assessment. With this focus, we are able to increase the accuracy and ethical responsibility to identify and serve students with disabilities.